you surely saw the response, though. I mean, I don't agree with that necessarily all of it was accurate, but it clearly seemed to indicate diligence.
Well, Your Honor, I'll cut to the chase and get to what I think is the strength of my argument. There was some explanation for why there was a period of time where plaintiff waited to serve defendant. There was some sort of explanation for why plaintiff waited to file a motion for substitute service. But Your Honor, motion for substitute service was filed on April 12th. On April 15th, a message was put up on the Dallas County website. And I say April 15th because it's dated April 15th. It says substitute of serve is missing the service attempts affidavit. Plaintiff never filed that affidavit until June 9th, which was 58 days later.
I agree. That's the weakest part of his argument. So I think that's the where we want to concentrate.
And Your Honor, I cited a case in my reply, Farmers versus McCabe, which in 2019, the Dallas Court of Appeals said 62 days from filing of the lawsuit to requesting citation was not due diligence, and then just approved the dismissal. Plaintiff in this case waited 58 days from the date of filing the motion for substitute service until the date of filing the affidavit in support. So that's 58 days compared to the 62 in Farmers case. But Judge, keep in mind, the 58-day gap in time was after plaintiff had already waited 103 days, right? So we were already well into this, Judge, at the time when plaintiff filed their motion. So I don't even think it's that close of a call, Judge. I'm not saying 58 versus 62. I'm saying there was an unnecessary delay of 58 days after we had already had a delay of 103, Your Honor. And so,
but if you take as true his affidavit that, and I've heard a lot of this around the courthouse, that there's been issues with the clerk's office getting citation done. I've never heard anything quite like what was recounted here, but it's not beyond the pale, actually, what I've heard. So anyway, let's hear back from Mr.
Your Honor, could I comment on that real quick?
Yeah, if you want to.
So, the case law says, Your Honor, don't explain to us why you didn't do anything. Explain to us what you did, Your Honor. And I say you being attorney, Your Honor, not you. And so I would say, Your Honor, that message was up there on April 15th. And so any explanation for why plaintiff's attorney didn't do anything doesn't cut the mustard, Your Honor. It's what did you do? And what was not done is that April 15th message wasn't seen and acted upon diligently, Your Honor.
I agree. That's the weakest part of his argument. So let's hear a response to that.
Yeah, if you may please the court, Your Honor. Happy New Year to you, Judge.
Happy New Year.
Your Honor, the facts are stated and the affidavit does cover that period. Again, counsel is right in saying the test is, do you have an unexplained reason? The affidavits and everything does delineate the dates and time, and there's certainly an explanation. The question is trying to insinuate is that explanation valid? I think that's what it's trying to say. But if you look at the affidavit, I don't want to bore the court with your time at this point. It definitely explains all of that. It's in the facts and the affidavits from due process service, communication between the court's coordinators and the plaintiff's lawyer and all that. So that's there. I think what counsel is trying to argue is that it's not valid, but it is there. The explanations are there. Now, the issue of validity, yeah, that's the second test. Is it reasonable on the circumstances what happened? We present to you that it is. What the explanations are reasonable under the circumstances, and what all we try to do to get this this stuff served. It is, in my opinion, reasonable. And the idea whether it seemed to me, if you look underneath what counsel is trying to argue, is trying to say, well, did he see some or didn't he see some? What did he do? That's issue to do with credibility, right? If you're trying to attack the credibility of the affidavits and what's already before the court, that's not, it's trying to get the court to walk into a reversible error here. Summary judgment, you just assume that everything we said, non-movement, is true. So if we've accounted for, which I think if you go through your honor, unless you want me to pull it up, and I know you go through stuff before the hearing, but it's all there. The period he's talking about, we've explained it. He's just not happy with the explanation. And that's not what the judge is required to do.
It just doesn't correspond with what's in the file. That's the issue.
He says something about amended. Well, can I just talk a little bit about that, Judge? We all know, we've been practicing law for a very long time. When you amend something, it doesn't necessarily mean that that stuff is wrong. We do it all the time. I guarantee you, counsel amended several things before. What it means, you find out an error of what you did, and you amended, and the court is not supposed to go and look back at what's there before, because when you amend, that supersedes what's there before. Now, if you supplement it,
I think the issue is that you guys were notified that there was a problem with the subservice, and it took you 58 days to correct it. And I think, Mr. Godoy, I don't necessarily, anyway, I'm not going to comment, but there is an explanation of what happened during those 58 days. He did provide some type of explanation about that. I don't know that that's an accurate necessarily representation, but there is an explanation of what happened during those 58 days.
Your Honor, just to highlight what I said before, I want to be very careful with my words here, Your Honor, but to highlight something you said, I mean, if there's questions about the accuracy, then I don't think we have to take any explanation for face value. You know, the case law cited in my reply states it has to be a reasonable explanation. And again, Your Honor, it's not an explanation for why you didn't do anything. It's an explanation for what you did, Your Honor. And there has been no comment, Your Honor, on why this April 15th message wasn't seen sometime before June 9th.
You know, we'll let you look at it. There's explanation for what's been going on. There was communication between the court, calling the court, going to the courthouse. Counsel may not be happy with the explanation, but to say there was nothing was done is inaccurate. There were things done. There was phone calls, where personal appearance at the courthouses. That may not satisfy him, but that's a different argument. That's the issue of, is it credible? And that's not where the court should be going. The reason for the high standard summary judgment, you want everyone to have their day in court. You don't want to win on some flimsy technicality and the scintilla of evidence to show that the case was actually trying to be prosecuted, and to just let the defendant walk away. That's the whole idea behind the high burden on summary judgments. So no, that's not true. For him to say that it is what wasn't done, things were done. There were phone calls, there were appearances in court. Counsel just doesn't like those things, and that's not where I think the court should be looking at.
Mr. Godoy, I do sympathize with you, and there's some things in that affidavit that seem a little bit, anyway, but I think I have to deny the summary judgment. So you guys have a great rest of your day. I'll sign the order, and you should have it by the end of the day.
Hey, Your Honor, real quick.
Thank you, Your Honor.
Plaintiff's MSJ response included a request for sanctions against me. I really have no idea what I did, Your Honor. But if you were going to,
No, of course not. We're not going to sanction you for it.
okay.
We're not asking for that, counsel. If we did, it was evident, and we withdraw it.
Okay. Yeah, you
Thank
have
you,
a
Judge.
legitimate argument there.
Okay.
Yes.
Thank you, Your Honor.
Thank you, Judge. Bye-bye.
All right, guys, you have a great rest of your day.
You too.
Thank you, Judge.
Thank you, Judge.
All right. Are both sides here? Kelly, is your opposing, Mr. Aiken, is your opposing counsel here, Mr. Aikens?
I believe so.
Yes, Your Honor. I'm Ken Patterson. I'm here.
Okay, I
I'm
can't
just,
see.
Somehow I have lost. Somehow I have lost my. Hello?
There you go, Mr. Aiken. You're not, we can see you, but we can't hear you.
And
I just
Megan
wanna-
Ferris is also with me, Judge. Megan Ferris is also
Okay.
going.
I just needed to chat with y'all real quick. We had talked a while back, and I just wanted to make sure I remembered correctly kind of what, did you guys want to bring did you want to select a jury on Wednesday, or just wanted me to, or kind of what is your expectation about Wednesday?
Your Honor, we wanted the panel to come in, fill out the jury questionnaires, and be excused until the following Tuesday, so that we could do it more expeditiously and pick the jury on Tuesday. so that we could try the Cook case, hopefully during the during next week completely.
How would y'all feel about if we just, I'm not necessarily opposed to that. What if we just did the whole jury selection? I hate to have 50 people having to come back the next week. What if we did the entire jury selection on Wednesday? Give you like a 2-hour break to look at the questionnaires and then do the jury selection in the afternoon. How would y'all feel about that?
I'd much rather do it the way that we had proposed, and I'd understood that it was going to be done. I'd much rather have the benefit of the jury questionnaire over the weekend.
I don't differ from that, Your Honor, but you know,
Do you see the issue though of having 50 people come back?
I do see the issue, and I
Or to-
so it would really, I could go either way, Your Honor.
I guess what we'll do is we'll do the questionnaires and hardships on Wednesday. We'll have 55 jurors come in. That's what we just discussed, right? 55.
Yes.
I believe so.
Have 55 come in on Wednesday. And you're going to bring in, you have the questionnaire all worked out?
Yes, Your Honor.
Yes, sir. Oh, Judge, we also have a statement that we'd like for you to read to the prospective jurors before
Sure. What is the
the
statement?
questionnaires picked out,
And
the questionnaires passed out.
one thing about that, Kelly, is I think Judge Hoffman may write his own according to Rhonda's information. We just
What is the statement about? I don't know what this
It's
is.
just, this is what this case is about, and
Oh, no, I that's perfectly okay. If you just want to give me a brief description of the case, that's fine.
okay.
Yeah,
And
that's actually pretty helpful, so I'm happy to do that. And I'll give, and remind me if I don't do this, just put this on your, that's not part of my normal speech, is I want to make sure I discuss the internet with them, not researching the internet. I usually wait until after jury selection to do that, but I want to do that during jury selection. So feel free to just whisper to me, hey, Judge, you need to. So we'll do that on Wednesday at 9. Tony, you'll need to come in on tomorrow and Wednesday. We are starting a jury trial tomorrow. They assured me it'd be done, but you know, that's something we may have to juggle. So, but we will see you. Make sure you have 60 copies of the questionnaire. You said it's all worked out, right?
yes,
Yes, I'm not sure we have the statement worked out yet, but we'll get it worked out. That won't be a problem.
Yeah, I'm more worried about I want to make this 100% clear. You need, because this happened recently, you need to bring 60 copies of the questionnaires with you on Wednesday.
Yes, sir.
Okay,
And then we'll pick the jury on Tuesday,
the next Tuesday.
the following Tuesday.
Yeah, but I need the questionnaires on Wednesday. I need
Yeah,
copies.
yes, sir. Of course.
All right, I think I'm just a little gun shy. That didn't happen that one trial, so.
Yeah. And Your Honor, one quick question. On the Wednesday, when they come in, Mr. Aiken's client, it's difficult for him to travel. And I don't know if you.
I don't want either clients to be there.
Okay, so it'd just be the lawyers there on Wednesday morning.
Have we already done motions and limines and exhibits?
We
Not
have done
really.
motions in limine, and the exhibit list is pretty well agreed to, Your Honor.
Let's.
I may have, as a result of some recent discovery responses, Judge, I may have some different exhibits to add, or at least demonstrative aids. And I can have those to opposing counsel, and we can discuss them on Wednesday if you'd like, or the day of trial.
So I may have already told you this, it's been a while since we chatted. I want a notebook that has both sides motion, one notebook. Did I already tell you this? Both sides motion and limines, both sides exhibits. You guys need to confer between now and Wednesday, and we're gonna deal with those on Wednesday as well after we do the questionnaires.
All right.
Or maybe before we do. We need to actually, we might want to do the motion in limine before we do questionnaires, but that's not, I don't think, critical. But yeah, make sure I have that notebook with all that stuff in it on Wednesday. All right, guys.
Yes, sir.
We'll see you on Wednesday.
Thank you.
Okay. Good to see you.
And give me 1 second. I'll be right back.
I don't know if our case has been called. This is Thomas LaCour. I've lost all audio.
Can you hear me? This is Pat LaCour, and the judge just stepped away for a minute.
Oh, I can hear Pat. Can you hear me?
Yes.
Okay. I know, but I can't. I need my hands.
I'm trying to get the heck out of Dodge.
That doesn't.
If you're looking
show
for
me
the
very
leap-
well.
Kelly,
guys.
top right.
All right, guys. So let's deal with the LaCour case now.
Thomas LaCour present.
Hey, give me a second. I haven't called it yet. Let's go on the record on BC 20-19352, LaCour versus LaCour. Council, make your appearances.
James
This is-
Carroll for James LaCour.
This is Patrick LaCour, pro se.
I'm sorry.
Has everyone made their appearance?
Thomas,
Thomas LaCour seems to be frozen. He was active a second ago.
I'm not hearing things clearly. Everything's breaking up. This is Thomas LaCour speaking.
And you are pro se, correct?
I'm yes, today. I'm sorry, is anyone speaking?
No, I thought we were announcements. Okay, has everyone made their announcements? Mr. Carroll?
yes, yes.
Okay, let's proceed.
Your Honor, I asked for clarification because what I recall from the court's findings is that the court found 3 agreements, each with James, that settled partition, and the court found nothing else, went and reached no other findings. In Counsel Carroll's proposed order, there seems to be a departure from that judgment and from the agreement, the $53,000 agreement between myself and James that settled the last of the agreements to sell to James. Explicit in 814 email from James and implicit.
I don't want to hear a new argument about this case. Is this the proposed judgment that you're talking about?
I'm sorry, I can't see it.
I'm sharing.
I magnify this.
Carroll.
The one that he submitted
Today,
today.
Mr. Carroll, is this the proposed judgment that you proposed?
can I see the second page? Yes, that's the proposed judgment.
Okay,
And the difference between the one that Mr. Thomas LaCour provided is that instead of 5 days after the judgment becoming final, he has 60 days.
That is what is in the agreement. And also, since the court made no other findings, the statement that all relief not granted is denied leaves Patrick's claims against
standard
me
language.
and mine against.
Mr. LaCour, that's standard language you put in every judgment. So there's nothing unique about your case. We put that in every judgment. So the main issue is this 5 versus 60. Is that the issue?
Yes, Judge.
So I just don't recall. What did I say at the time of trial? I thought we addressed this.
You
I
said
don't-
that,
Go ahead.
well, my recollection was that you found that the agreement was valid. You made no specification regarding when it was valid. I assumed that it meant when your order was final. The agreement says within 60 days. So if that's the case, then it should be 60 days. And that's why I was trying to point out, there's evidence already before the court that James made no claim that we had an agreement that was extant. In fact, he explicitly denied it. And
I don't want to hear.
until the
about-
12/16.
Yeah, I don't want to hear argue about this.
Well, I'm
What I'm
only
inclined to
gonna get
do
it.
at this point is just take out the, I'm not going to put any number of days in there. I'm just going to say with that James LaCour is ordered to pay the sum of 53,000 to Thomas LaCour. And that's it. And then you can enforce the judgment like you would any other judgment. All right, guys, thank you so much. You have a great rest of your day, okay?
Thank you, Judge.
Thank you, guys. All right. So
So which one counts? Yours or his?
LaCour, you need to sign on.
Good afternoon, Judge.
Good afternoon. We're actually, you have double duty today. I don't know if you knew that.
No, I did not. Me has double duty?
You have double duty.
Okay,
So just so you're aware.
okay.
At a perfect timing. So Ms. Enze and Mr. Crane, Mr. Ticer, my recollection, I'm pretty sure I'm right about this, is that Ms. Armstrong is the court-appointed mediator in this case.
Correct.
So before we start these hearings, other hearings, let's go ahead and, since we have Ms. Armstrong here, let's go ahead and pick a date that the mediation can take place.
Judge, we actually did that heavy lifting already by agreement. We're on February 17th, this Friday.
Oh, this Friday. Okay, so it's already done.
Yes,
Correct.
yes.
All right.
Everybody's been
Yep.
playing nice in the sandbox to get that scheduled.
All right. So, well, that's good news. Thank you guys for doing that. So you can just, I guess it would probably be more appropriate, Ms. Armstrong. Actually, I don't really know if it is appropriate or not. We're about to hear some summary judgments on this case. Do you want to hear those, or is that appropriate for you to hear?
I can if you think it's going to help edify me, and I defer to the parties on that. I would ask that, because apparently there has been some concern that any agreement that we reach, procedurally, how do we make sure that that happens? That is something I know that is important and integral to the parties. For Ms. Enze, as an example, if she receives an agreement, when she signs on that agreement, I'm confident she's going to want remittance. And so is that something that we can do in court, when the presence of the court, but certainly in your presence, Your Honor, to build the confidence for Ms. Enze that an agreement is really going to happen? She really will be compensated if we can reach that on the 17th. Obviously, this would be someday later, but that would be your mediator's suggestion.
So I'm not going to be in Texas on the 17th. So
No. It would be someday later. We mediate on the 17th.
I'm sorry. I'm sorry, I misunderstood.
We
you.
mediate on the 17th. So in
Okay.
the event that we reach an agreement in writing amongst the parties, the
Um,
handoff.
I'm perfectly okay with that if that works for Mr. Crane and Mr. Ticer and Ms. Enze. If there's a date that they want to come in and exchange the check and the releases and all that kind of stuff, I'm perfectly okay with that. So there's no problem with that. I know you have another hearing with me, Ms. Armstrong, so let's go ahead and.
I do, Judge. My next friend actually has a meeting for work at 2, but she'll be available again around 2:45, if not sooner. So
Let's bring everyone in. Let's bring everyone in then and talk about that. So she is the next friend here. Is that? No,
she was here. She was logged on, Judge, by phone.
Jones?
No, that's a defense counsel.
Okay, and Jenny Moman is the plaintiff's counsel, right?
Correct. Miss Keisha Jones is our next friend, and we were on the phone with her at
She's
1:55.
on Zoom right now. She's joining us right now.
Okay.
So Keisha,
Excuse me, I'm sorry, so sorry, Your Honor. Can I change my baby's diaper? She blew out her diaper like literally 2 seconds before this started. Can I just change it really fast?
yeah, go ahead.
Okay, thank you. Oh,
All right, so is Miss Jones here, or I guess it's unclear. I guess it says she's joining, but it's not actually joined. So you said that she has something at work and she wants to do this at 2:45. Is that?
She actually has another Zoom, a mandatory Zoom meeting at 2 o'clock. So she may be trying to hang on. We asked her to hang on just so we could visit with you about this and ask the court's indulgence to let us
Yeah.
allow her to work and then
Let me
pop
just-
back on.
Let me just double check and make sure that's going to work.
Okay.
So I'm just going to check my docket.
And she's still on. I will send her a text message, Judge, to see if maybe something happened on her end when she's able to move forward now. So let me send her a text.
Yeah, it says she's joining, but she hasn't joined yet.
Okay. Mr. Tyser, are you a part of that other matter? Kelly, you'll coordinate with Mark Tyser on the other matter.
Yes, I'll
Okay.
make sure that that we're handled on our side.
Okay.
I'm not sure. Miss Keisha Jones has dropped off the Zoom. She's not here now.
Okay. That would have been why, Judge, just so that she could probably be present at her work meeting, and she said it would last maybe half an hour.
Okay.
So if that works for Your Honor and Mr. Jones, Ms. Moment and I will try to make sure Miss Keisha Jones is available back at 2:45.
Okay. Yeah, just let me hear from this moment since she's contacted.
Yes, Your Honor. I just texted her and she said, yeah, she's on now with the job. This mandatory meeting at 2. So she's assuming like 30 or 45 minutes it'll take.
Why don't you guys sign back on at 2:45?
Will do, Your
Okay.
Honor.
All right.
Thank you.
Thank you. Okay, give me 1 second. I need to come. I'll be right back.